Hi everyone, welcome to Seminar 7 of Applied Company Law, where we'll be discussing directors' duties and fiduciary duties. Today, the case that we've been given involves the company Build It Proprietary Limited. Build It Proprietary Limited owns several prime office buildings in Sydney which they lease to corporate customers. The directors of the company are Simon and Robin, and since January 2020, business has been slowly declining, with construction work around the city and office spaces being left empty. In April 2020, they decide to appoint Hannah as non-executive director. Hannah is a high-profile lawyer and works long hours in her firm and takes no active role in the company. She rarely attends directors' meetings because she's working, and she only took this role at the request of Robin, who advised that the company is really busy and business is booming. Robin assured Hannah that she would not need to look at numbers or figures. By December 2020, a liquidator is appointed to the company to investigate a couple of events. At a board meeting in May 2020, it was resolved that Robin would look for other prime office buildings around Sydney. In June 2020, Robin negotiated a purchase of a $6 million building in Maroubra. Robin didn't disclose that the building is actually owned by her father-in-law. She's given a red packet donation from her father-in-law for negotiating the deal, and it contains a $10,000 check inside. At the end of June, in a board meeting, Robin gives a presentation to the directors and gives them a 100-page report, which contains an expert evaluation which advises that the flight path for Kingsford Smith Airport or Sydney Airport is being rerouted to fly directly over the new building in Maroubra. All the directors present were at the meeting. Following the meeting, the company proceeds with the purchase of the Maroubra office building. However, the building actually can't be tenanted out due to the noise overhead. Upon appointment of the liquidator in December 2020, Robin paid her employees a payment of $20,000 each, totaling $2 million for their loyalty and service to the company.
To give you advice whether Beauty Pty Limited is able to recover loss as a result from Robin of breaching her direct duties, these are the legal issues we need to identify. Issue 1. Whether Robin breaches direct duties to avoid conflicts of interest and secret profit. Issue 2. Whether Robin acts in good faith in the interest of Beauty Pty Limited. Issue 3 is about Hannah. Whether Hannah breaches duties of care and diligence as a non-exclusive directors. Issue 4. Whether any defenses are available. To answer these legal issues, these are the key rules to direct duties. Under Corporation Act 2001, Section 180, Subsection 1, it indicates that director and his officer have to act with reasonable care and diligence as their duty and obligations. Section 181, Subsection 1, Good Faith, explains that director and officers have to act in good faith and for proper purpose. Section 182, Subsection 1, and Section 183, Subsection 1 further detail what our directors and officers prohibit to do in their position and the information obtained from their position to act in good faith. They also relate to concepts of conflicts of interest and secret profit. Furthermore, Section 191, Subsection 1, and Section 194, Subsection A, tells us that any director's gain of material personal interest must get consent or disclose to other directors in the company's directors' meetings, unless under Section 191, Subsection 2. Section 180, Subsection 2, Section 189, and Section 190 gives ideas about what remedies are available. Section 1317S tells us what civil penalty that directors are liable for. In addition, some general law that is reinforced in statutory law, for example, no profit and no conflicts rules, is reinforced in Section 182 and Section 183. For limited term case, is reinforced what shall be considered as secret profit. Some other cases coming up in the following slides to support our legal issues as well.
So now I'm going to be explaining about the first issue, which is whether Robin breaches her director's duties to avoid conflicts of interest and secret profits. The rules that are relevant to this issue is the case law of First Limited and Tomkins, and also the Queensland Mines Limited and Hudson. The statutory law that are relevant to this issue is the Corporations Act 2001, Section 182, subsection 1A or B, Section 183, subsection 1A or B, Section 191, subsection 1 and 2, and lastly is the Section 195, subsection 1A. So now we apply the law. In terms of the statutory duty, the Corporations Act 2001, Section 182, subsection 1A or B, and Section 183, subsection 1A or B, rules that directors, other officers, and employees must not improperly use their position to gain an advantage for themselves or someone else, or cause detriment to the corporation. In this case, Robin is the director of Build IT Proprietary Limited and is given the responsibility to look for other prime office buildings around Sydney. However, she gained advantage of $10,000 right bracket donation for herself from her father-in-law by negotiating the purchase of the building in Marlborough, which then caused liquidation to the company because the building in Marlborough cannot be tenanted out. Therefore, Robin breached her director's duty under the general law in Section 182 and Section 183 without disclosure. Furthermore, Robin must disclose the personal material interests to avoid conflict of company's interests under the Corporations Act 2001, Section 191, subsection 1A, where material personal interest means that it has the ability to influence the director's vote. Otherwise, Robin breached her director's duties as the director's decision to purchase the building may change if she disclosed the hiding informations to Simon and Hannah, the other two directors, regarding the owner of the building, which is her father-in-law, as well as the $10,000 that is given from her father-in-law. This case is similar to the case law of First Limited and Tomkins, which indicates that no director shall obtain for himself secret profits in purpose above the best interest of the company, unless he or she disclosed material facts to the company. Otherwise, the director breaches Section 191, a duty on fiduciaries to avoid conflicts of interest, that is to disclose the material personal interests. Moreover, Robin did not disclose that her father-in-law owns the building in Marlborough, which distinguishes the case of the Queensland Mines Limited and Hudson. And thus, the Corporations Act 2001, Section 195 does not apply, and it is not suitable for Robin, as Build ID is not a public company.
The second issue I'll analyze is whether Robin acted in good faith in the interest of Build Company. The laws I use, including statutory law of Section 1A1, subsection 1A, and 3 case law. Now I briefly introduce the case law. The case of Percival and Wright refers to acting in the interest of the company as a whole. The case of Kinsella and Russell mentioned that husband and wife are the directors and shareholders in the family company of Kinsella. In the shareholders meeting, they agreed to rent out the business premises at a price lower than market value when the company was insolvent. After the company was put into liquidation, the liquidator challenged the transfer of the lease that the directors had breached their fiduciary duties in failing to consider creditors' interest when transferring the lease at undervalue. The final decision of the case is when the company is insolvent or approaching insolvency. The directors are obliged to consider the interests of creditors. Another case, the Park and Daily News, talked about the board of directors has decided to pay £1 million to their former employees when they sold the business. Shareholders sought to prevent this happening as they thought it was unreasonable and has damaged shareholders' interest. The decision of this case is the interests of shareholders are damaged. The company has no reason to pay $1 million for the former employees. The proposed payment was not reasonable when the company no longer operated and were ultra and illegal. Next slide, I will talk about the application. According to Section 1A1, subsection 1A, and Percival and Wright, the director should act in good faith in the best interest of the company as a whole, that is, financial shareholders as a general body. In this case, since December 2020, a liquidator is appointed to the company, means they enter insolvency. Applying Kinsella and Russell case, the primary beneficiary of directors' duty would change from the shareholders to creditors as a whole. However, robbing paid $2 million to employees has damaged creditors' benefits when the company is insolvent, thus not acting in good faith to creditors. The fact is different with Park and Daily News case, which mentioned the payment to employees is damaging shareholders' interest when a company is solvency. Therefore, Robin does not act in good faith to creditors. She breaches her director's duties of duty to act in good faith.
The insurance rate is whether handler breaches duty of care, diligence, and are there any defense available. The rule is following the Business Judgment Rules, Section 118, and Delegation of Responsibility to Other, Section 189, relying on other Section 190. In the application, considering Daniel and Anderson case, the duty of the care and diligence for exacting director and not exacting director are the same. In addition, in the center case decision, all directors, including not exacting directors, should understand the business and base financing literacy, which means handler is responsible for necessary monitoring of financial figure. However, Hannah rarely attended director meeting and focused on her own job as a lawyer in other constitution. Therefore, the Corporation Act 2001, Section 118, Part 1A and B applied would Hannah's behavior, and she breaches the duty of care and diligence that potentially cause loss of purchase Robin's father-in-law's building. In addition, Hannah failed to meet full condition of business judgment rules under Section 118 Part 2, as she take no active role in building its sole judgment, which is not good fair to the company. She did not read relevant information, such as tracking number for the report, and her behavior indicates that she did not care about the company's best interest. Furthermore, as Hannah chose to believe Robin and did not access the information independently, as well as did not make any delegation, cannot reply on defense under Section 189 and Section 190.
The fourth issue our analyze is, are there any remedies for liquidator to recover money? The laws I use is including the company laws of Section 1317, 206C, Section 1A4, and the general law. Applied to this case, liquidator can apply for general law remedies, including account for profits and damages compensation. Robin should be asked to hand over the 10,000 of red packet to liquidator and a compensation for the loss of buying the building to help the company recover the loss. Because Robin also breaches the statutory duty, liquidator also can apply the statutory remedies, which is civil penalty provisions under Section 1317. Request the case decision of disqualification order under Section 206C, compensation order under Section 1317H, and pecuniary penalty under Section 1317G. In this case, Robin should bear the legal consequences like be dismissed by the company, give back the red packet, and also have fines for damage loss to the company. Besides, liquidator can apply the criminal penalties under Section 184, which mentioned if director breached the Section 181, 182, and 183, may jail. As mentioned above, Robin indeed breaches the duty of Section 181, 182, and 183. She may have the criminal penalties. Therefore, these remedies can apply to Robin.
In conclusion, there are 4 issues. The first is Robin breached her direct duties to avoid conflict of company's interest under Corporation Act 2001, Section 1A2, subsection 1A or B, Section 1A3, subsection A or B, Section 191, subsection 1 and 2, Section 195, subsection 1A, following the secret profit and misappropriation company property. The second issue is Robin breached her direct duties to act good faith of the corporation under Section 1A1, subsection 1A, and the general law. Issue 3, Hannah did not exercise reasonable care and in the breach of her direct duties of care, skill, and diligence under Section 1A0, subsection 1A and B, and general law, and she has no defense available as she did not satisfy the condition under Section 1A0, subsection 2, Section 1A9, and Section 190. The last issue is liquidator can use remedy to help company to recover money under general law and Section 1317, Section 106C, Section 1317H, and Section 184.
And so that concludes our presentation. Thank you for listening.